Welcome to Trust's Wills and Wealth podcast, protecting what you've built and planning for what matters.
Welcome to the Trust, Wills, and Wealth podcast, protecting what you've built and planning for what matters with Isaac Cohen, the podcast where we break down complex estate planning topics into clear, practical guidance for California families. Isaac is the founder of the Cohen firm, where he helps individuals protect their assets, their families, and their futures. I'm Evan Mack, and today Isaac will walk us through what really happens when someone passes away without an estate plan in California, from probate and court involvement to who actually inherits your assets. He will explain the consequences of not planning ahead and why the state's default rules may not align with your wishes. Isaac, sir, welcome.
Thank you, Evan. It's a pleasure to be here. Good morning to you.
Good morning. Good morning. The pleasure's all mine. Welcome, Isaac. So let's jump in right with the burning question, really everyone should be asking, which is, why is having an estate plan in place so critical?
Well, in California, it's extremely critical. It puts you and your family in control over what happens to your assets. California has a default probate process where if there is no plan in place, the state will decide who gets your property, under what circumstances, and does it through the court system, which means that process can take anywhere from a year, 2 years plus, and keeps you completely out of control. So having an estate plan basically says, I want to be the one that takes care of my family, that makes sure that my assets go where I want them to go, and the way I want them to be divided.
Wow. So what's one of the biggest misconceptions people have about, dying without an estate plan in California?
Probably it's that, my estate isn't big enough. I don't have enough money. I'm not a multimillionaire. I don't need an estate plan. I don't need a trust. The problem with that is that in California, as we know, property values have grown so high that anybody that owns a piece of property, even a small condo, or if they have assets worth about $184,000, around that figure, or any more than that, if they don't set up their own trust, the state will do that for them. So again, if you have assets, even a small property, real estate, investments that's worth more than $184,000, and we're talking gross value of a property. So if you have a $1 million home, which is not even out of the ordinary now, and if you owe $900,000 to the bank, the state still sees that $1 million value, not the amount that's owed, and you go to probate.
So speaking about what you said earlier, does everything automatically go to your spouse if you die without a plan, or have you seen other things?
Not necessarily. California is what's known as a community property estate. So community assets that husband and wife accumulated or obtained after marriage, normally that will go to the spouse. However, there's also separate property. So any property that a spouse had prior to the marriage, that brought into the marriage, any gifts, any inheritances, a business that was started prior to the marriage, that would be considered separate most of the times, and that will not necessarily go to the spouse. In fact, if it goes through probate, the court has a schedule as to who can claim the property, how it will be divided. So some property can go to children, some property can actually go to parents, and not having the estate plan can place a spouse in the position where he or she is going to be sharing assets with family members that they weren't really considering to share with originally.
So Isaac, does not having an estate plan almost always mean probate in California?
Just about always, yeah. Probate is the default. So probate is the court process that's been set up so that when somebody passes away, their estate meaning all of their property, whether it's real estate, whether it's personal property, which would be bank accounts, investment accounts, vehicles, things like that, before they can get passed down to either the next generation or to whoever the person that passed away wanted that property to go to, the court takes charge and has to notify potential creditors, notify potential claimants, people that say, well, I have a share in this property. They have to inventory the property. And then they have to supervise, once all that's done, the distribution of the property based on the court's own criteria. And unfortunately, that takes anywhere, from 12 to 18 months, and oftentimes more than that. So not having an estate plan usually means going through probate.
And speaking of that, though, how expensive and time consuming is it if there is no estate plan in place?
Very expensive, unfortunately. The reason is the fees for probate are actually set by law. It's statutory. So what they do is the court will inventory, as I mentioned, all of the property, the gross value. Again, you have a house that's worth $700,000, okay, and there's $500,000 owed to the bank. Doesn't matter. 700,000 in my example is what they're going to look at, and the fees to the attorneys, to the administrators, whoever is appointed to administer this probate, will be set by law. It's a percentage of that gross value. So you're talking just with this property that, in my example, $30,000-$40,000 in attorney's fees and in administrator fees. And
Wow.
that gets paid right off the top. So lawyers are very happy. They get paid right away. Administrators also. And that's money that could have gone to the children, to the spouse, but that gets paid first. Whatever's left over after all the fees, that's what gets distributed to the beneficiaries.
So will my assets freeze during the legal process if I do not have an estate plan in place? What is the typical timeline of that legal process if that ends up happening?
Great question. And unfortunately, the answer again is yes. There's a blackout period. So once the probate is open, and it takes time to open the probate, you open the probate, the court is going to freeze most assets, meaning there's bills to pay. There's mortgages, oftentimes there's, just the regular bills that are outstanding until it's determined who is going to be the executor, who is going to manage the probate, how this is going to be distributed. Well, mortgages aren't getting paid. If there's a business, a family business, the business isn't getting run. If the person that passed away is the only one, in a small business that signs the checks, that makes the decisions, well, until that probate gets cleared up, until that blackout period is lifted, nothing's going to happen. And unfortunately, we've seen where small businesses collapse because of the probate process, where the intention was this business is going to be passed down to my kids, or we have a succession plan in place. It doesn't happen. So yes, things get frozen, unfortunately. Timeline, blackout periods can last months. Probate period can last years, and that, several months, 12, 18, 24. And that's the biggest problem. If we can avoid probate in California, we want to avoid probate.
So Mr. Cohen, if you own a home or business in California, what risk do you face without an estate plan?
Well, with a family business, we just touched upon that. So again, even with the succession plan in place, the court might see it otherwise, number one. And with assets being frozen, with bank accounts being frozen, without having somebody authorized to make the decisions and sign the checks, businesses can fail. That's horrible. Real estate is also, you're looking again at taking the property through probate. So if there's no estate plan, the court again is going to decide through the probate process how title to that property is going to be passed down, how it's going to be distributed. Another thing is there's tax issues. And we're not a tax firm, and we're not going to provide tax advice. However, we can tell you this. If somebody has a proper estate plan in place, has a living trust, and a home is passed down to, let's say, the children through a trust, when they receive that property, it's as if they bought the property and actually paid value for it. Even though they're just receiving it, they pay zero capital gains tax, and that's huge. The converse to that, obviously, is that if it goes to probate, They receive the property once probate is finished. Again, a year plus since the person passed away. And all of a sudden they have a big tax bill because they receive a property. Again, in my example, it's $700,000. A property worth $700,000. Well, they have to pay capital gains tax on that $700,000. So if they have the money, whatever it's going to be, whatever that effective rate is going to be at the time of the distribution, to write a check to the government, fantastic. They write the check. It's a big check. And then they'll be able to keep the house. Many times, as is often the case, they don't have a couple $100,000, just sitting in the bank that they can dispose of. The house gets sold, the government still gets paid, and then what's left over goes to the children. So to avoid that, and we call that the probate tax. Have an estate plan in place. It's really quite simple, and the benefits are astounding.
So what sort of family conflicts can evolve if you don't have that estate plan in place in the state of California?
That's also a good question. So again, with the estate plan, the person who sets up the trust, or the couple that sets up the trust, they state with real clear specificity, how the property is going to go. It's going to go to our two children in equal shares, or the first thing we're going to do is give a donation to this charity of this amount, and then the rest is going to be split, however it is. Without that estate plan, number one, the court is going to see, okay, what are the assets and who are the claimants? So you have the children, possibly have parents, could be other claimants as well. And if they're not in agreement as to what's supposed to happen, if they say, what, Dad always loved me best, and Mom, I was always Mom's favorite, so the house really shouldn't go 50-50. I should get 60% or 70%. Or wait a second, why is anything going to charity? Dad spoke to me at one time and said that he changed his mind and he wanted that really to go to the kids. But mainly, it's if you have any discord in between siblings, between potential beneficiaries, then that invites conflict to come into court, for them to work it out or battle it out, and spend money and spend the estate's money to come up with a resolution. If you want to avoid that, you set up your estate plan and you're real clear. This is the house and it goes to child A, child B, and these are the percentages. Done. End of story. Same with the money. Same with our personal property.
Wow. So, and before we go, what would you tell someone who is conflicted, wondering if they do not have that estate plan in place, if it's worth the cost of hiring that experienced estate planning attorney to at least consider the options?
That is also a very, very good question. And I'm going to answer it, I guess, with another question is, what's the cost of not doing it? And we've touched upon a lot of that. If somebody wants control over what happens to the family's assets, again, it could be a single person, it could be a married couple. The fact that they allow the state or the court or a judge that has no idea about the family dynamics, about what you really wanted, make these decisions for you, is extreme. Again, we talked about the probate tax. If somebody is willing to allow tens of thousands of dollars of their estate to basically go to administrators, attorneys, and court costs before their children or before their spouse, depending on the circumstances, before they see anything, then they can say, okay, I don't need an estate plan. But anybody that really wants to avoid that says, no, these are my assets, this is what I built up, and this is how I want things to pass, it's a no-brainer in that sense.
Oh, great stuff. Thank you, sir.
Pleasure. Thank you, Evan.
All righty. And thank you all for listening to this episode of the Trust and Wills and Wealth podcast, protecting what you've built and planning for what matters. If you want to learn more about protecting your family and avoiding the consequences of having no estate plan, visit thecohenfirm.com. Don't forget to like, subscribe, and share this episode. And thank you so much for listening. We'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.